published by Cambridge University Press. Before we listen to your questions and we engage in a dialogue, I would first invite our colleague, Cecily, to say a few words about the book. Cecily, the floor is yours.
Thank you very much, Rizwan, for organizing this event, for taking the initiative to do this. I really appreciate it. And it was also a nice opportunity for me to reflect on the experience of having written the book, co-authored the book, and also on how we'll move forward with it. And I would really value your questions and those of the participants' comments and feedback later on. So I'll speak a little bit, and then Daniella, one of the other co-authors, will speak for a little bit as well. I thought it might be helpful for me to begin by giving a little bit of my own background and how I came to the point where I decided that it would be a good idea for us to write a textbook. And for me, a really formative experience that I had was when I was a PhD candidate in Cambridge, at the point at which James Crawford, who is my PhD supervisor, was taking over the Brownlee's Principles of Public International Law. So I believe it was the 7th edition then, which became Crawford's version of Brownlee's Principles of Public International Law. And James had basically an army of PhD students and assistants who were helping with that revision. And what we found was that a lot of the footnotes, which are so valuable in that book, required updating. But it just so happened that the chapter that I was assigned to work on required more than just footnote updating. And so that experience of being involved with that chapter gave me some insight into the textbook writing process, and in a way demystified the process of writing a textbook a little bit. And it gave me just enough experience to have some confidence that I could maybe write a textbook myself. And James was the kind of supervisor who, well, I never had the opportunity to tell him in person about our own project, but I know that if I had, he would have, I can just imagine his reaction, which would have been a kind one. He would have smiled and said something encouraging and kind to give me a sense that indeed it was possible and that I could do it. So that brings me then to my time, not in Cambridge, but in Leiden, and how it was that this came to be a departmental project. So the department that we were a part of at the law faculty in Leiden is the Department of Public International Law. And there's a lot of us, it's a large department. And altogether, at the time that I joined the department in 2013, the various colleagues in the department, including myself, were responsible for teaching public international law at an introductory level in various parts of the university. So including the third year bachelor students at the Liberal Arts College in The Hague, which is a part of the university. So those are not law students, but rather undergraduate liberal arts students. And also at the time, the department was teaching at the Faculty of Social Sciences. And there, I think that course was specifically designed for the students who were at the master level, but studying international relations. And what I noticed, I think most of all over lunchtime conversations, was that everyone seemed dissatisfied with the books that they were using for the courses that we were teaching at that time. And so I'll speak to my own dissatisfaction. And I think these are important points because these then became my and our objectives for this textbook. Well, so my first point of dissatisfaction was that many of the existing books at that time were simply not for an introductory audience. So not for students who are studying public international law for the first time or for the first time in English. And so what I mean by that is that the books were too complex, assumed too much knowledge, or had chapters that were just way too long for bachelor students, for example, studying this topic for the first time. And I felt strongly that those books couldn't even be assigned. And so that includes, unfortunately, the very book that inspired me, Brownlee's Principles of Public International Law. I feel that that book is for a more advanced audience. So I felt that assigning those books would be doing a disservice to my students. And then there was a separate category of books which I felt didn't adequately support my teaching. And this was the problem that I think I felt most acutely. You know, I would select a book hoping that it would really suit the course. And what I found, not just once, but twice or three times, was that basic subjects really just weren't covered adequately enough to support my teaching. So we're talking about subjects like self-determination, which I would really hope to see either in a chapter on subjects of international law or in a chapter on human rights law. But I actually found in multiple books that that topic was covered really only in passing. And for me, that was a very important subject. And it wasn't just me, it was for all of my colleagues an important subject. So as a result of these problems, I sort of cycled through a couple of books in my first couple of years of teaching. The other problems that I noticed, or sources of frustration, were that I felt that a number of books didn't cover a given subject in a balanced or objective way. So I saw that some books emphasize the particular author's views to such an extent that I felt that the students weren't getting an objective, weren't going to gain an objective understanding of the particular subject area. There was one textbook in particular that I can recall that happened to give side issues in the field of public international law a great deal of emphasis. So for example, a chapter on state responsibility that included a quite lengthy section on compensation. And I remember feeling quite guilty about my poor liberal arts students being assigned that chapter on state responsibility. And then of course, there were also some chapters, some books that emphasized the case law of a particular domestic jurisdiction, which was something that I also thought was sometimes unfortunate, especially if the case law being emphasized was British case law, and none of my students were particularly interested in British case law, nor did they need to know that in order for them to have met the learning objectives for my course. Now, one final point is that I felt that many of the books also gave examples, but didn't really give examples. So what I mean by that is that examples were mentioned of how the law applied in practice, but many times knowledge of the given historical event was assumed and not explained. And in fact, I noticed that, yeah, indeed, my students would have been infants at the time that some of the events took place. So their knowledge absolutely could not be assumed, and proper explanations were needed in the text. Otherwise, students would have to look up those historical events separately, which I think in many cases never happened. So the chances were great then that the books remained at an abstract level for the purposes of the students, insofar as the examples weren't really serving their purpose. So I'm belaboring these problems because these gave rise to our goals, which were to ensure that we were covering basic points like self-determination, that we were doing that in an objective way, and in a way that was balanced and didn't overprivilege any particular viewpoint, and that we gave good examples and really explained what happened, so that a student who had no prior knowledge of that particular event, whether current or historical, would be able to understand the examples, so that the examples would have meaning. And finally, another goal was that we wouldn't emphasize or prioritize any given legal system. So this is not a book written from the perspective of Dutch domestic law. And indeed, I wouldn't really be able to afford to provide that perspective because my legal training is in the US and the UK. So just a few brief words then on and how we wrote the book, moving on from why we wrote it to how. So this is a co-authored book, which I recognize is unusual insofar as we had 7 co-authors, such that all of our names couldn't go on the cover. But interestingly, Cambridge University Press had no problem with the fact that this was a co-authored work by 7 people. So my role then was as the lead co-author, and also as an editor, but my primary function is as a co-author. It wasn't initially the plan that I would write half of the book. That became the solution, the way that we eventually completed the book after a number of years. And this was really then a team effort. And it was conceived of from the beginning as a team effort, because we saw that within the department we had a really nice complementary set of fields of expertise. So from environmental law to dispute settlement, international criminal law, international organizations, and that it would be in a way easy for us to assemble a textbook in light of our various fields of specialization. I can say though that, and I think this is just common sense, that a team of 7 is unwieldy. So that's a lot of people. So, you know, I can't pretend that it's easy to coordinate 7 people, because that means you're coordinating 7 different calendars and writing styles. So that's a challenge. I'm writing a book now with 2 other colleagues who are at other universities. And I think, yeah, a team of 3 or 4 will inevitably be easier to manage than a team of 7. So in terms of the challenges that we encountered then in writing the book, for me, I enjoy textbook writing. So for me, it's a very particular type of writing. It's not like writing a blog post or an academic article or even an encyclopedia article. And for me, one of the biggest challenges is the decision about what to include and what to exclude, and how to structure what it is that you've decided to include. And so I think those are choices that have to be very consciously made. You know, it can't be by accident that a particular issue is addressed at length while other issues are not. And decisions about how to structure the chapters, I speak for myself here, I really took those decisions independent of how those particular subject areas were addressed in other public international law textbooks. So I really tried to come to my own decisions about what the best manner was for structure, for organization. And then I also spent quite a bit of time thinking about examples. So yeah, the work on the textbook proceeded over the course of years, and those were years in which I was sort of busy assembling nice examples for the chapters. And I think that will remain the case if there's hopefully a second edition. Just other practical challenges involved ensuring uniformity in chapters that were written by 7 different people. So uniformity in terms of length and style. But I think we managed. The chapters in the end are really almost all exactly the same length, and I think have a relatively similar styles. So I was happy with how we met the challenges it presented. So Daniella, I'll pass the floor to you then.
Thank you, Cecily, and it's a pleasure to be here and to be able to tell something about our book project. So just going back to what Cecily said about the why, and why I was so enthusiastic when Cecily came with this idea for this book project. So at the time I was teaching and coordinating our BA3 course, so the 3rd year bachelor course. And in Leiden, we have 2 mandatory courses in the bachelor. So in the 1st year, all the basic doctrines are covered. And then in the 3rd year, there's more space for going into other fields of international law. And that immediately, of course, presents yourself with problems, because when you're looking at the textbooks that are out there, and you want to cover international law in all its breadth, so including international humanitarian law, environmental law, international economic law, then there's little out there that is at a basic level. So the book that I used was a great book in the sense that it was very inspirational, and it covered indeed all the different fields, but it was not systematic. So that meant, for example, that when you prepared an exam, that you could not really ask questions about the book. So you were completely reliant on your own lectures, basically, for exam questions. So that was an important reason why I was very enthusiastic when Cecily came with this idea, because I mean, you can criticize what's out there and be dissatisfied about what's out there, but of course, I mean, taking the next step and saying, well, we're going to write our own book is something else. So that for the why question. Then something about the choices, in any case, that I made in the chapters that I wrote. So I wrote a chapter on international environmental law, and I wrote the chapter on the use of force together with Niels Blokker. So for the environmental law chapter, I basically I based that chapter on my lecture notes. So I had used these, I had built actually, because the textbook that we had was not so suitable, I had actually built a whole lecture and outlining how international environmental law as a field of international law distinguishes itself from other fields. So I took that as the basis for that chapter. And then, of course, I elaborated on that. So that chapter is, I think, very different from what you usually see in textbooks, because usually when you see an environmental law chapter in a textbook, it starts with the important conferences, Stockholm in the 70s, Rio in the 90s, and it goes in a sort of chronological fashion through these conferences. Then usually it singles out a couple of conventions and it discusses how these conventions work. And that is what I did not want to do, because what I wanted to do instead was to discuss international environmental law as a field of international law. So what are its main characteristics? What is the fabric of international environmental law? And so looking at the principles and how these evolved over time through these various conferences and through conventions. So, so the chapter discusses the evolution of these principles. It discusses core characteristics of international environmental law. Also, some of the major concerns, of course, that international environmental law aims to address, but not from the perspective of particular conventions, but from the perspective of these concerns. So, for example, the conservation of flora and fauna, or combating pollution. And so from these two broad themes, and then looking at how various conventions contribute to addressing these concerns. And so it's a very different approach. So that says something about choices. And the same for the use of force chapter. It was a very conscious decision for the use of force chapter to also include, for example, sanctions. And so usually sanctions are not covered in a chapter on the use of force because, of course, they do not directly pertain to the use of force. But on the other hand, when you look at it from a more systematic perspective and you look at how the UN Charter regulates the use of force, then it makes sense to start with sanctions as a means to actually prevent, to contain use of force. And so that is a slightly different perspective, but it tells something about choices and about how to approach particular topics and how we did that in this book. And I think, Cecily, you probably have many more examples of other chapters, but this is just to illustrate a bit. So that's it.
Thank you, colleagues, Cecily and Daniella. We already have one question from one of the colleagues. one of the participants. Before I move on to that question, let me just ask you one introductory question. I noticed that in the foreword to the book, Sir Christopher Greenwood has written that this is not just a book or a textbook on international law, but also for other disciplines. So how have you achieved that this could be potentially used by scholars from other disciplines? Could you elaborate on that, please? Thank you.
Yeah, I think from the very outset, we were aiming to write a book that would be usable by lecturers teaching, in particular, international relations students and political science students. I hope that we've achieved that goal because at the time that we undertook this project, we were as a team teaching at the social sciences faculty in Leiden and also at Leiden University College, which is a liberal arts college. And so the idea was that we would use this textbook to teach not only students at the law faculty, but students at these other parts of the university. So then that meant that we were aiming to write a book that would have to be really careful about how it explained legal concepts, to not assume too much knowledge about the field of public international law, or really any prior knowledge. And also, this is more of a language issue rather than a disciplinary issue. But the course that I now teach in Leiden for the third year bachelor students is in English. And it's the only, if I'm not mistaken, the only mandatory course for the Dutch bachelor students in law. And the fact that it's in English, it makes it a challenge, and it made it especially important that the language used in the textbook would be accessible to non-native speakers. And that the language used would also be accessible to people who aren't lawyers by academic background. So that is to say that it's not a book that's intended to be used by only by other disciplines, but it is intended to be used by both lawyers and non-lawyers. I hope that's clear.
Thank you so much for that answer. Now, I would now like to combine two questions, one from one of our colleagues, Siddharth Mallavarapu. I hope I have pronounced his name correctly. And also a question from me, that we know international law is still very much a Westphalian system where states are at the core. But we also know that increasingly individuals and international organizations and other actors are an integral part of this international law system. So how much have you focused on actors other than states in the book? And to add to that, the question from Siddharth, he has thanked you for your contribution, and he asks, I quote from him, to what extent the book addresses the broader collective of the Global South as an active actor in public international law? Do critical sensibilities like third world approach to international law feature as an integral part of the approach? So two questions together. Thank you.
Yeah, thanks very much. Well, I'll start with your first question. So I think I can say, it's fair to say that the textbook definitely covers non-state actors, individuals, corporations, international organizations, sub-state actors, actors seeking self-determination. So the chapters, for example, on subjects, statehood, and self-determination, international organizations, human rights law, and international economic law very much address the position of non-state actors, to use that umbrella term. So individuals then factor in, of course, to the chapter on international human rights law, corporations in international economic law, individuals as investors, and then entities that are pursuing self-determination. So non-state actors, other entities that are pursuing self-determination in the second chapter of the book. So I feel that non-state actors are covered fairly extensively in the chapters that we've written. Now, as for the question from one of our participants, as is explained in the introduction to the book, we've admittedly taken a positivist approach to explaining at an introductory level the field of public international law. And so that has entailed then a decision not to feature or highlight other approaches to the field of public international law, whether theoretical or from another discipline, for example. But we acknowledge that choice, and we've made that choice because we think that this is the best way to introduce the field, and that those other perspectives and academic approaches ought to be brought in at a later and more advanced stage. But I think that those other perspectives and approaches are extremely valuable, but perhaps too challenging for introductory level students who are just struggling often to grasp the basic material.
Thank you. Thank you for that excellent answer. The next question that I would like to put to you will be on your use of materials that highlight the practice of international law, not just the rules of international law, because I think in the book's overview, and also somehow you alluded to this in your introductory words, that you have not only focused on international law, but also on the practice of international law, that what happens in reality on the ground. So could you give some examples of taking that approach? Thank you.
Sure. Daniella, shall I begin, or would you like to say anything?
No, perfect.
Okay. Well, one of the fields in which I do research is international dispute settlement. And I happen to have written the chapter on international dispute settlement here. And I made an early choice to give plenty of space in this chapter to non-binding means of dispute settlement. So by that, I'm referring then to negotiation, mediation, inquiry, and conciliation. And these are aspects of international dispute settlement that I think are not always emphasized in textbooks. But I felt it was really important to give space to those other forms of dispute settlement, because in practice, this is what you see much more than resort to the International Court of Justice or interstate arbitration. And I don't want students to walk away with the impression that states are regularly resorting to the ICJ and that it's the ICJ that matters most. And I say this as someone who used to work at the ICJ. So I love reading those cases, and I love having the opportunity to teach them. But I really want students to also understand that most disputes are resolved through mediation, through negotiation, and to a much lesser extent through inquiry and conciliation. So that's, I suppose, one example. Another example would be that in the chapter on the law of treaties, I really tried to find examples that were new and that pointed to how current affairs can be seen from the lens of the law of treaties. So, for example, I gave a couple of examples that concern Qatar. One concerns Qatar's reservations to human rights treaties, which I think is an ongoing live issue. Another example concerned the Riyadh agreements between Qatar and a number of Gulf states, in particular Saudi Arabia, and how those agreements arguably create rights for a third party, Egypt. So that's an example that's not coming from an ICJ case or from any judgment or award, but examples that I was aware of from my own research that I thought could be valuable for students who could have a window into how these treaty law issues, which can seem complex and abstract, how they do have practical relevance. Danielle, is there anything you'd like to add?
Yeah, well, I think in any case, the practice comes very much also from the examples that we use. So, for example, in the use of force chapter, there are many examples of specific peace operations or situations that were brought before the Security Council and how that worked in practice. In the environmental law chapter, I have regularly noted that certain, for example, that there is a possibility perhaps to invoke erga omnes obligations, but that it's not so much used because of political, political reasons, but also some more practical reasons why international environmental law, for example, developed so slowly and why it's so difficult. So really looking at not just, okay, so these are the conventions and these are the principles, but also looking realistically about how it functions in practice, limitations that are inherent in of course, the political setting.
Thank you very much to both of you for your answers. Now, we have another question from a colleague, Max Hillary. She is asking and she's actually first making the point that she also teach the same level of students in the US and face some challenges that we face. Now, her question is, or her approach is, she uses several articles from legal and social science journals in addition to her own text. The evolution and transformation of international law, developments in international law from the Peace of Westphalia to the post-United Nations Charter, which she thinks gives students a broader perspective on international law and a diversity of views. Now, she seeks your views on what do you make of such an approach? And she congratulates you. Oh, sorry, I should say it's a he. I beg your pardon on your publication. And I sincerely apologize for that mess on he and she. I apologize.
Well, I think that sounds like a great approach. I'm assuming that he is teaching JD students in the US. Is that correct? I hope that's a correct assumption. If it is, I think that assigning secondary literature academic articles is perfect. And I do that for my master's students. I teach a course on international dispute settlement for master's students, and I assign them, well, unfortunately, I don't actually have a textbook that I can use. So I do my best to compile a nice complementary set of secondary literature for them. For the undergraduate LLB students who I teach in Leiden, I don't assign academic articles because I know that it would fall flat. I know that it's too difficult, they're too long, it's too much. It's enough to ask them to read them, for them to read 1 or 2 textbook chapters and cases. And I assign 2 cases per, fairly lengthy excerpts from 2 cases per class, so per week. But I complement that with blog posts, which I've very carefully selected with the help of one of our PhD students in Leiden to ensure that students have then a range of different perspectives. So we've really looked for blog posts that show, for example, a TWAIL perspective, that talk about developments that the students may or may not have read about in the news. The goal is to allow the really motivated students to read further and to be exposed to more than they can get through my lectures, plus the small group teaching that we do. I hope that's responsive to the question. Daniella, would you like to add anything?
Yeah, no, I think, I mean, of course, it's great if your students, if you can introduce your students to various views by giving them academic literature. But I agree very much with Cecily on the point of, in any case, our bachelor students that personally, I prefer a textbook that is comprehensive, because then you introduce them to the core concepts and ideas, while you can use the lectures, for example, to elaborate on various views that are out there. But I think in any case, in my experience with articles, is that what you're looking for usually for students, in any case for teaching, is sort of descriptive article. And I think especially if you look at academic journals, of course, it's not descriptive. So students are thrown into a debates that they're not aware of. So if you use that for teaching, I think, and that's probably what you do in class, it needs a lot of, you need to provide a lot of context for it to actually land. And that's why I think it's perfect for master students, but I'm more hesitant with respect to bachelor students.
Thank you so much. Maxillary has clarified that basically he teaches political science and higher undergraduate measures. Now, Siddharth has asked a follow-up question. He says, I would like to know how the book views the relationship between international law and world politics.
That's a good question. Well, let me begin with my first sentence. Public international law represents the legal architecture of international affairs, at least in my view. And I've written further, often this architecture is hidden behind world events. Sometimes, however, the language of international law is in plain view, such as when individuals assert their human rights or when one state accuses another of violating the laws, let's say, governing trade. The further point that I make is that much of international affairs, including front page news, can only fully be understood within knowledge of public international law. So in other words, I think an introductory level course in public international law is needed in order to be able to understand the news, just what's on the front page, what's going on in Ukraine, for example, one of many examples. So for me, the link between law and politics is very close. And that you need to have an understanding of the law in order to fully understand how politics is operating. That said, when world leaders sit around the table to make decisions, I'm under no misimpression that international law is always their top priority or is the main factor guiding their decision making. But I do think it's part of the architecture. I do think it's there, at least in the background, if not in the foreground.
Thank you. Daniella, would you like to add anything to that?
Yeah, no, I mean, I agree very much on that. In the if for example, if you look at how states communicate with each other, for example, now in the current crisis with respect to Ukraine, and the types of justifications, for example, that are put forward by Russia, or you see that states are using the language of international law, and for that reason alone, it's important to have an understanding of what that language is to understand the full scope of political relations.
Thank you. Even if states may not always adhere to international law, at least they often seek to speak in the language of international law. So maybe there is hardly any disagreement on that, Daniel, I would like to add. Now, the next question that I would like to ask maybe is a bit premature question, but nonetheless I would ask. Let's say if you were to write an edition 2 of your book, or in retrospect, you would have done something differently, what chapter or chapters you would have added, or what changes you would have made, perhaps? Any thought on that?
Yeah, that's a good question. I don't necessarily feel that we needed to include more chapters. I've given a lot of thought to that. I mean, there are certainly other subjects in the field of public international law that we could have included. The book is in two parts. The first part covers the foundations. So treaty law, sources, state responsibility, etc. The second part covers what I'm calling the branches of public international law, like human rights law, international economic law, environmental law, etc. There are other branches that we could have covered. So we could have covered refugee law, cultural heritage. We could have had maybe a whole nother part on different perspectives. So or on different theoretical perspectives, or the history of public international law. But I think that a lot of those subjects belong in a more advanced textbook. And I also question whether there are many lecturers out there who are teaching introductory level courses that really delve into those subjects to such an extent that you would need a whole chapter in a textbook on that subject. And if there are, I would love to hear about it, because I really hope to receive feedback, direct feedback from other lecturers on the book and whether it works for them, and if not, what they would want to see changed. But my one of the goals, I think, was to keep the book at a manageable length and to have it more or less match what people are teaching, so that it provides an adequate basis for our own teaching, but also hopefully for teaching at other universities. In terms of what I would do differently, well, I suppose I was, in the end, fairly satisfied with how it all came together. But I think the process of putting together a second edition will be a challenging one for me by virtue of the fact that I've never done that before. I've revised my PhD dissertation prior to publication, but that's sort of a different kettle of fish. But here I think we'll have to really keep an eye on current developments, decide what should be included and what not. Maybe also take a really close look at the domestic cases that are being cited in the chapters, to the extent that we're citing domestic cases, and whether that's a representative global set of cases or not. I also happened to notice, fortunately prior to publication, that many of the chapters in their draft versions cited recommended literature that was predominantly by male authors. And it was a strong trend, which I think is really not needed. There's a lot of really great female authors out there in our field whose work should and ought to be cited. So I think we'll, in the revision process, have an eye towards how the book has been received, what needs to be changed so that it continues to be representative of the field and the authors in the field, and reflective of current events. What do you think, Daniella?
Yeah, I think the main challenge will be with updating some of the examples that are used will need to change, but also the law develops so quickly that it's very difficult to find a balance between, on the one hand, showing the most recent developments, and on the other hand, making sure that the book is in any case ready to go for 4 or 5 years before you actually revise. So, for example, when I wrote the environmental law chapter, that was before the Human Rights Council adopted the right to a healthy environment. So that changed like so fast. And of course, there are so many changes undergoing, especially, I mean, most fields are, of course, so dynamic that that I think is the major challenge. Yeah.
Thank you to both of you for your answers. Now, the next question would be on, let's say, a young colleague who had just embarked on teaching public international law, and she or he wants to write a textbook on international law. Yes, there is already quite a few of them out there. Your one is a very good addition to this. But perhaps this is a subject where you would always have some space for new writers, new thoughts, new books. So do you have any advice for such a young colleague who would like to write a textbook on public international law? Thank you.
My advice would be to try to find 1 or 2 colleagues to do it with you, because it's a lot of work, not to be underestimated. And I enjoy this type of work, but I think in many respects, collaborating, working with other people allows for a better output. in the end. So I myself really benefit from working with other people. So that's the first thing that I would recommend, to not do it all by yourself. The second thing I would say is to be gentle with yourself in terms of how quickly you expect yourself to be able to produce it. So this is not the sort of thing that happens overnight. It takes takes years to be able to clear enough time in your schedule to be able to write a whole textbook. So to be realistic and kind to yourself in terms of what you can really expect and how much time it's going to take to get it done. And to be sure that you like this type of writing, right? So it's not like writing an academic article or a blog post or lecture notes, right? It's not even most akin to writing lecture notes, because lecture notes will just simply never be as detailed as what you put in a textbook chapter, nor should they. So it's a particular form of writing. You have to be quite disciplined in not, going beyond your ideal word limit by too much, being objective, giving a balanced picture. Those are all things that I think demand a lot and shouldn't be underappreciated if possible.
Yeah, no, I think in some respects it's even more difficult than writing an article, because when you're writing an article, you're making a point. Well, when you're writing a textbook chapter, you really have to think about how does this message come across? What aspects should I include? What aspects should I leave out to make sure that it's accessible to readers? And I think that's, of course, you do the same for an academic article, but I think this is a more difficult exercise. And I think one advice that I would give you is try to already test something on your students. So once you've written something, test it, see how they, whether they like it, whether they understand it. So that might be a good start also.
Thank you. The next question that I'd like to put to you is, I think at the very beginning, Cecily, you were talking about being objective, and also just in your answer to the last question, you were talking about not being too opinionated. Now, my question is, perhaps basically we international law academics, international lawyers, and maybe even law students, we are by nature a bit opinionated. And when it comes to academia, we are always trying for our own voice. So, but I agree with you that in a project like this, we need to be objective. But how objective can we be, and how can we strike a balance between making our voice and being objective?
Yeah. Yeah. Well, I suppose I may have overstated my point, because we can't really be properly ever fully objective, right? We all have our own backgrounds and influences and ways of seeing things. So all we can really do is just do our best to be as objective and nuanced as we can, to not have students walk away with a impression that would be misleading. In other words, I suppose that's my main point, to ensure that the introduction that students get gives them the right sense of the shape of the law and how it's functioning in practice, without giving them a cynical picture or an overly utopian one. But of course, the way I approach topics is bound up in, at least partly, in where I was educated and my professional experience as a lawyer before I joined the university. So I think, if anything, my approach is informed more by my time at the International Court of Justice than by my education in the US. But I know that we all have our experiences which inform how we see things, and that's inescapable.
Daniella, any thoughts on that?
Go ahead.
No, I mean, I think that's the most difficult thing to really make sure that you do not impose your own views on your students. But yeah, I mean, it's impossible to escape your own education. So it's in that sense there will always be maybe a bias. But that's also why I'm very much looking forward to others providing feedback. Also, when they think that maybe something we wrote does not reflect other understandings, and I mean, I see this also as an opportunity to actually engage with others, and I really would like to know how others perceive this, and if there are certain biases that maybe I'm myself not even aware of, that send me an email. Yeah.
Thank you. And an open invitation to us to communicate and to hopefully see a less biased edition 2 in 5 years or 7 years. I'll put it that way. The next question that we have is from Siddharth again. He asks, does the book engage the political realist skepticism about the efficacy of international law?
And to an extent. So I address this also a little bit in the introduction to the book, in which I talk about compliance a little bit and enforcement. And the point that I'm making there is that I would encourage international lawyers and scholars from other disciplines and students from law and other disciplines to be as much as possible nuanced in how they think about enforcement and compliance, because it's too easy to jump to the conclusion that public international law has no real effect in practice because it's not easily enforced. There's no hard sanctions, for example. But in my mind, there's plenty of nuanced reasons why states do modify their behavior as a result of their legal commitments under public international law. And I think that we've tried to show that here and there in the book, and to paint that nuanced picture to the extent that we can. At least I hope so. And I look forward to, I would appreciate feedback on that for those of you who might adopt the textbook.
Daniella,
anything to add from your side?
No, I think it's a bit, on the one hand, of course, I mean, you have to show international law, how it realistically functions and also its limitations. And I think we're frank about that. On the other hand, I think it's also maybe our responsibility as international lawyers to oppose a bit this skepticism with respect to international law, and to show also where it does function well. And also, as Cecily says, so several alternatives also. But so, for example, for the chapter on international environmental law, I mean, an often heard criticism is, of course, that international environmental law does not really have enforcement mechanisms. But I think if you look at the compliance mechanisms and you look at how these function, that you have a more nuanced idea of what is going on. And I think that's also, what a textbook should do. On the one hand, there are limitations, and be frank about it, but on the other hand, also show within these limitations what can be done.
Thank you very much. The next question that I would like to put to you, although I know that Cecily has already addressed this in a way that due to her education or legal education maybe in the US, she is not perhaps even the expert to take a Dutch perspective to international law, but inevitably all the contributors are from the Netherlands. So I was just wondering, because I haven't been able to read the entire book, I have the pleasure of reading a couple of chapters. I was wondering that, is there anything in the book that somehow directly or indirectly reflects something Dutch? And secondly, I would like to ask, often a criticism that I have for many of the mainstream international law textbooks is, if you read the table of cases, you would feel that maybe the world means the US, Western Europe, and some other places in bits and pieces. There's hardly any case that I would see from Asia or from Africa, or even from the Oceanias. So what about your book? How have you covered the domestic law cases? I know it's easier said than done. There are thousands of them, but could you say something on that? Thank you.
Well, yeah, I definitely wouldn't say that the book takes a Dutch approach or even cites very much Dutch case law. The Urgenda case is cited in the section in the table of cases, in the section that lists national cases, but I must say that's a short section. But your observation is true here, that we're mostly citing Western case law, but we're citing national cases to a much lesser extent than we're citing arbitration awards, court decisions, judgments. So I would say that the references to domestic case law are relatively limited in the book, and then we're mostly dealing with international decisions. The chapter on jurisdiction, for example, is probably the Dutch heaviest of all the chapters, insofar as that the person who wrote that chapter, Eric Koppe, he did cite domestic Dutch legislation to illustrate some of his points. So that chapter has a Dutch, a Dutch accent to it, which I think is fine. But for the other chapters, I think that can't really be said. Yeah.
Thank you. Daniella, anything to add to what Cecily has said?
No, I think in any case, in the chapters that I wrote, well, the Urgenda judgment is indeed the only Dutch case that I mentioned, but of course that is because it had a precedent function internationally. And I think everywhere where it's about climate change litigation, the Urgenda case is cited, so it would have been odd if I had left it out. But I do indeed not see this as a Dutch book. If anything, maybe a Leiden book, because I think that there might be a Leiden approach in the book. But of course, I mean, we are a very international faculty at Leiden, so I think our perceptions and our approaches are also very much influenced by this international cooperation. So yeah, no, I would not say Dutch, absolutely not.
Yeah.
Thank you to both of you for your answer. We are almost out of time, so this would be our last question. This is again from Siddharth. He asks, is there anything in the book about the history of international law, especially the link between colonialism and international law, as argued with clarity in the work of scholars like Anthony Angi?
Well, the historical topics are covered not in a dedicated chapter, but often at the beginning of a given chapter. So, for example, there are historical elements to the chapters on the law of the sea, international criminal law. Those are examples of areas that have a longer history, for example, in particular, the law of the sea. Also, self-determination, of course, is very much tied up in colonialism, and that's covered at quite a bit of length in the second chapter of the book. So yeah, I think that colonialism, decolonialism, and historical aspects of the field are covered, though not in a dedicated chapter.
Thank you. Daniella, anything that you would like to say on this?
No, I think, but it is something, of course, that we need to consider, maybe also for the revised edition. Maybe not even in the form of an additional chapter, but maybe something in the introduction, because this is, of course, one could say it's an old discussion, but it has revived a lot over the last couple of years. So this may be something that that we need to include in the book, or in any case, raise awareness among students about the matter.
Yeah, I begin my course with the Mauritius advisory opinion, which I use as an opportunity to discuss those issues. And I do it with pleasure.
Thank you, Cecily and Daniella. Thank you, colleagues who have attended. For me, it has been a very lively discussion. I have enjoyed your questions and, of course, the discussion of the authors on the book. I wish them good luck for their book. And I hope, colleagues, you would attend in our the next webinar that we organize on behalf of this group.